Thank you, Mr. Chairman. Thank you, panel. As you all know, the Fourth Amendment provides the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. In other words, protection against unreasonable government searches is a fundamental right. Mr. Downing, as the courts have made clear in their rulings, all evidence that is obtained through an unconstitutional search is inadmissible in court. Would this exclude all the tracking information, even the information obtained where the suspect had no reasonable expectation of privacy, like driving on public roads?
So the constitutional suppression would only apply to that information that is indeed protected by the Constitution. So if the court found that the information was not implicating the Fourth Amendment, then constitutional suppression would not apply in that situation.
Okay, so then what are some examples of situations where a warrant would not be necessary when placing a GPS on a vehicle?
There might be situations that come up where there is a life and limb emergency, for example, where the courts have long recognized that the warrant requirement doesn't apply. So, for example, in that situation, law enforcement officers could search a house without a warrant because of the immediate need. Those kinds of exceptions would apply also in the case of tracking devices on vehicles.
Mr. Liu touched on this a bit. What should be the legal standard for historical geolocation information?
I'm sorry, was that question to me or Mr.
Yes, yes, sir.
I apologize. Historical location information?
Yeah. What should be the legal standard for historical geolocation information? In other words, why would you have less interest, or why would you have less privacy interest in where you were last Saturday than where you'll be next Saturday?
So the Department's position is that historical cell site information does not require a warrant, and 3 circuit courts have agreed that that's the case. The reason that it is different is that it is less precise in general, that it is a business record collected by the company, that it is not continuous but only recorded when communications occur. And so for all of those reasons, it's a different category of information than, say, real-time GPS information that's collected prospectively. For that reason, the courts have recognized that it does not have a constitutional protection.
How far can law enforcement go back? A year, 3 years, 5 years?
The amount of time that you could go back would all depend entirely on the record collection and retention practices of the company, because these are company records that are not mandated to be stored. It's a choice that the companies make. And so it's variable. Some go back for a short period of time, others for longer.
Ms. Giuliani, would you like to comment on or share your opinion on those issues?
Sure. You know, as I mentioned before, we believe this distinction between real-time and historical information is artificial, not just because of the increasing accuracy of cell site information, but also because of the very real privacy interests that Americans have in protecting the fact that they've been to an AA meeting 6 times in the last week, or the fact that they only sleep at home 5 out of 7 days a week. With regards to historical cell site information and the time period that providers keep that information, in some cases that can be close to 5 years, for example in AT&T's case. With Sprint, 18 to 24 months. And that's incredibly intimate information about someone's life. And given this, we believe that a probable cause warrant, the same standard that would apply if law enforcement wanted to read a letter of yours, is the correct standard.
Mr. Downing, do you agree with that?
With all due respect, do not agree. The reason that this information is different, first of all, let me say, we respect that it is private information, and we believe that it should be protected. We believe it is protected. The Electronic Communications Privacy Act already creates rules. It's not at a probable cause standard, but nevertheless, it is quite protected and not instantly available to law enforcement whenever it chooses. We have analyzed, though, the constitutional rules here and have taken the position that the Constitution does not require a probable cause standard for the reasons that I explained before.
Ms. Giuliani, do you agree with that?
Respectfully, we disagree, and there are many courts that have recognized that historical information is extremely sensitive. For example, a Fourth Circuit opinion that is awaiting en banc review, where the court found that historical cell site information was sensitive and should be provided a higher standard. I think it is important to note that states across the country have recognized this, have recognized the sensitivity with which Americans view this information, and have on their own adopted, in many cases by nearly unanimous votes in their state legislatures, legislation that protects historical and real-time cell site information. And given this trend, both at a state level and both in terms of the American view of this information, we feel that this is a case where it's ripe for Congress to make clear that this information should be afforded a higher level of protection through legislation and by pressing the Department to change its policies and its position.
Thank you both for your time. I yield back.
Thank the gentleman.